Hello everybody, my name is Paul Bedame and I am an attorney with the law firm of Rubin and Bedame in Norristown, PA. And we specialize in obtaining Social Security disability for our clients. So today I'm going to talk to you a little bit about how the application process goes. So first, if you were to hire us, we only get paid if we win your case. We get paid from your retroactive benefits only. That means your back benefits. It's 25%, capped at $6,000. So, for example, let's say your back benefits are $10,000, and then your monthly benefits thereafter are $1,000 a month. We would get paid 25% of that $10,000, which is $2,500, and then all of your remaining benefits, the $1,000 per month you would get, they're all yours. We don't get any bit of that. But let's say your retroactive payments are a total is about $40,000. So 25% of $40,000 is $10,000. But we're capped at $6,000. So no matter how high your retro is, we can't get more than $6,000 with that cap. And again, your ongoing monthly benefits, they are all yours. We don't get paid from that. So if you decide to hire us, of course, after you sign the paperwork, we have you fill out an information packet. The next thing that we do is we file your application. And we do all of our applications online. That's the quickest and the most efficient way, and in my opinion, the most accurate way to get an application done. That takes us maybe a couple hours to do the application online. Once we do that, your case then gets sent to the district office, wherever you live, and then from there, it gets assigned to an adjudicator. So we're located in Pennsylvania, so I'll give you kind of a step-by-step example of how it works in Pennsylvania. And this is pretty consistent throughout the United States, and we practice Social Security law and handle cases in all 50 states. So once your application is filed, the district office then sends it up to Pennsylvania DDS. So DDS stands for Disability Determination Services. That's a department with the state of Pennsylvania who is contracted by Social Security to handle the initial part of your claim. So after about a month, an adjudicator is assigned to your case. So that adjudicator's responsibility is to obtain all of your medical records and to send you out forms to fill out. So typically there are two forms that are sent out. The first is called a functional report, and the second is a work history report. So we ask all of our clients after they fill out their functional report or work history report to mail those documents back to us. When we get them back in the mail, we'll call the client and we will review that application with them to make sure that it is accurate and correct. Once it's reviewed, then we fax it straight over to the adjudicator at DDS. So the initial process, that typically takes about 5 to 6 months. And if you're approved, wonderful, case is over, you get your money, boom. But if for some reason you're denied, we both get notice of the denial and we file an appeal. That appeal is called a request for reconsideration. So once the appeal is filed and for reconsideration, your case gets assigned typically to a separate adjudicator. That adjudicator will send you out the same forms again. And I don't know, it's another crazy reason. I don't know why they send you out the same forms to fill out again, but same process again. You get those forms, fill them out, send them to us. We review them with you. Then we fax them over to Social Security. And then they obtain updated records for you. Or when we review the case, if they missed any records, we make sure that they get those other records that they might have missed. Once they get all your updated records, then your case is sent to the medical doctor at DDS to determine whether or not you meet their criteria for disability. If you do, wonderful, you're approved at reconsideration, boom, we're good to go. But if not, then we file another appeal. And this appeal is called a request for hearing before an administrative law judge. So typically, I'd say 2 to 3 years ago, from the date the request for hearing was filed, it used to take approximately anywhere from 18 to 28 months to get a hearing before a judge. As of now, September 2020, in this area, in the Philadelphia, New Jersey, Maryland area, Delaware, it's taking anywhere from as little as 5 to maybe 10 months to get a hearing. The times have been cut dramatically, the wait times. And I could sit here for about an hour and explain to you why that's happened, but we'll leave that for another day. So, your case is then scheduled for a hearing before a judge. They have to give you, by law, 75 days notice, so which is about 2.5 months. So, right at about the 2-month mark before your hearing, before your scheduled hearing, we set up a phone conference with you where we go through, we have all the electronic access to your file, which includes all of your medical records and their initial decision and reconsideration decision. Then what we do is we go through those records, we obtain anything that might have been missed, and then we also get your updated records. So the updated records are from when you were denied up through the hearing. And then we also typically will send you out what are called medical source statements. And these are also called treating source statements. They're for your doctors to complete. It's a residual functional capacity, whether you have a physical impairment, a mental health impairment, or both. We also have forms for seizures and for migraine headaches. So not all doctors will fill them out, but nonetheless, we send them to you. We ask that your next appointment with whatever doctor it is, you give them to your doctor, and hopefully they complete them. Sometimes they do, sometimes they don't. It just typically depends on the doctor. So once that's done, and once all your records are in, we submit them electronically into the system. It's called the ERE, the Electronic Record Express. And the day before the hearing, I like to do my prep. I think it's the closer you are to the hearing, the better it is to do prep. So I do all my preps either the day before the hearing, or if your hearing's on a Monday, we'll do the prep on Friday. And prep typically takes anywhere from 45 minutes to maybe an hour and a half. And we just review, I tell you how the hearing goes, what the procedure is. We're very familiar with the judges in the area. My partner and I, Scott, we've had them numerous times. So we typically know how they hold their hearings, whether they ask a lot of questions or whether they rely on the attorney to ask the questions. So we prepare the client, and then you typically the next day or that Monday is the hearing. Then the hearings, right now we are in September 2020 with COVID. All of the hearings right now are over the phone. But typically, if they're not over the phone, we meet the client on the day of the hearing at the hearing office about 45 minutes to an hour early, prep them, give them a little pep talk, prep them again, just review some things for the hearing. If it's a phone hearing, we'll typically call them, that morning, or, if it's an afternoon hearing, that afternoon, just to review again, a few things and, calm the client down if they're a little bit nervous, and then we have the hearing. So the hearings, they could take 20 minutes. It could be 2 hours. It just depends on the judge, and it just depends on the kind of case. Once the hearing is done, typically you don't know what the answer is or what the judge's decision is going to be. So you have to wait. And the judges can't just press a button or click the mouse on something to approve or deny a case. They have to write up a whole legal opinion on whether they're approving or denying your case. If it's approved, great, we're in great shape, we'll win the case, which we typically do. But if for some reason it is denied, then in about 95% of the cases, we'll take the case to the appeals council. That's sort of the appellate court for Social Security. And that's not another hearing at that level. What we do is we prepare a brief, and submit it, and we argue to the appeals council why and how the judge erred in denying your case. And then the appeals council, it typically takes them about anywhere from 8 to maybe 14 months to make a decision. So hopefully my explanation of how a typical case starts and evolves and ends was helpful for you. And of course, if you have any questions or if you'd like to hire us as your attorney, you can contact us at 610-382-5200, or you can go to our website, www.rubenandbadamelaw.com.